Zeynep Ekinci. She is from Kabin Law Office in Istanbul, Turkey, but she is also a solicitor in the UK. And she just finished her dissertation, which I know she's going to tell you about, on NFT art and NFTs. So she's phenomenal and we're excited to hear from her.
When we're talking about NFTs, it's really important to know a little bit about the technical background, right? Because we as lawyers, we tend to not delve into too much technical discussions because we're not computer scientists. However, we are at a point that we have to understand what is going on. And in that respect, I find it that it's very important to know the difference between an on-chain and off-chain NFTs. So basically, what is it? We have the blockchain, which is a distributed ledger technology, and the NFTs are based on that. If we're talking about on-chain NFTs, it means that the NFTs and all kind of other files attributed to that NFT is actually on the blockchain itself. So some people claim that it is the one true identifier of authenticity because it's right on the blockchain. But we have some limits for this because we are not in a limitless storage time. We have technical limitations as to having on-chains. That's why, for example, the CryptoPunks 24 pixelated images were what came to people's minds when we were first started talking about NFTs. There were really small pixelated images and they were on-chain because it's very, very difficult to put something more developed than that on the blockchain itself. However, there are off-chain technologies as well. As far as I'm aware, there are like two different methods of doing this. One is you can use like IPFS or other kind of technology to store the information on other nodes, so, which is like more secure, but which is more distributed, and you can just put another link on somewhere off-chain. So these kind of differences are actually important nuances that we have to be aware of when we're talking about this, because when we're talking about an on-chain NFT, I think it's more readily that we combine the underlying artwork or something else with the NFT itself, whereas for other instances, especially for off-chain NFTs, it's not the case.
Do you have a question?
Yeah, I did. Just before you move on to intellectual property, it's true. One of the things that seems striking about Bitcoin as a protocol is that it accords real property rights in this decentralized manner. It's rights control and exclusion, all of this stuff. So it seems this point about whether the actual item is part of the NFT goes to the heart, or is it a property? Can you enforce real property rights around this in this decentralized way without intermediaries?
This is something that I think Zeynep can speak to certainly better than me.
Thank you, David. This is actually one of the, I think, most fascinating questions that we think when we think of crypto assets and NFTs in particular as well, because this it's a nice discussion that I've actually put a special part in my dissertation as well. So basically, what are NFTs? I was writing a dissertation about the NFTs and their implications on art law, and the first thing that you have to do when you're writing a dissertation is to give a definition about what the thing is that you're writing. And I actually ended up doing research for almost 1.5 years in order to understand whether there are properties or whether the current property rules can be applied to the NFTs or crypto assets in general. So I'd like to give just a little bit of context into their qualifications as property. I am coming originally from a civil law country, Turkey. I'm based in Istanbul, but I also have solicitor qualification in the UK. And I think it's very striking to have this difference between common law countries and civil law countries as to the definition of property and how readily they are to accept, property definitions. So what we do in the civil law countries, we wait for regulations to come and we wait for discussions which are going to point out how we're going to behave any kind of technological new developments. Whereas in common law countries, I think you are a little bit much more in luck, especially I'm speaking for the UK, because even though the property rules are well established and they're dating way back and probably consisting the pillars of liberalism that we see in the United States and the UK and economic principles that lay the foundations of the systems today, but they're more prone to changing because you can adapt them through commentaries of judges. So if we have a look at the European approach, for example, we are coming across a very major problem to qualify NFT as a property, because in the civil law countries, we have some criteria. We don't have exact definitions, or we don't have exact definitions from case law that we can adapt to any kind of crypto asset. Rather, for Switzerland and for Germany and for Turkey and most of the civil law countries, and France as well, even though France is just a little bit different because they have like a categorization, but anyhow, there are some principles that are required in order to qualify something as a real property. And for the Swiss and Turkish approach, I would say they are materiality, specificity, eligibility for dominance, and it's the discernment of your rights over someone else's. And what is the big problem that we have with property is that NFTs are not tangible, and this tangibility criterion is actually very, 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 very different and difficult to surpass in civil law countries. Let's take Germany in the example. They're called Sache, things in possession. And if it's not a physical being, you cannot call something Sache, which is already crossing out the crypto assets in general. Whereas what did the UK do is the UK Jurisdiction Task Force in its launch of legal statements of crypto assets, they explained the case law, and I think the relevant case law is the National Provincial Bank Limited versus Ainsworth.